Good afternoon. I'm Janice Silver, Vice President of Programs and Marketing for the Cable Center. We are glad to be a champion sponsor of C2HR. I'm excited to introduce our next session, Employment Law 2020. Before I introduce the speakers, I want to remind you that this session is being recorded and will be available for on-demand viewing afterward. Today, we have two experts who will share their insight on employment law, focusing on COVID, social equity issues, and other employee classification issues. The session will feature a live Q&A at the end, so please post your questions by using the Ask button at the bottom of your screen. We are thrilled to have Mark Konkel and Barbara Hoey with us. They are co-chairs of Labor and Employment Practice for Kelley, Drye, and Warren LLP. Mark and Barbara, thank you for being with us today. Let's get started.
Okay, I think we're going to start the slides. Greetings, everyone. As Janice was so lovely to give us an introduction, my name's Barbara Hoey. Nice to meet you all, even virtually, which is, I guess, the way it goes in 2020, which is why we're mostly talking about all things COVID, and then the things that are still out there that aren't related to COVID, because that has been the biggest challenge, certainly, of this year. It is remote working, returning, or working in an office versus remote working. I say return to work. There are people who never left their offices, or certainly in your industry, people who have not been working remotely, and you have to continue to make sure that they show up for work. And the ever-changing location of work. Those are all the things that have made this year, frankly, something unlike any other year. So Mark, when we go to the first slide, and so the first thing we're going to talk about is COVID leave. And that is really a misnomer, because what we're really talking about are all of the different kinds of time off people are now requesting because of COVID. And these things all intersect, which is why we really couldn't put any one on any one slide, because everything melds together. And if you're in the HR field or you're an in-house attorney, you've got to think about all of these things as intersecting. So what's your biggest issue? Your biggest issue is having a claim by an employee that I was either interfered with when I was attempting to take a leave, or I was denied a leave. That's claim number one. Claim number two, which is frankly all in the same bucket, is retaliation. So that's the person who is either being retaliated against because they requested a leave, or because they had taken a leave in the past and now have returned to some different sort of situation. And then you have just plain old disability discrimination and failure to accommodate, because all those employees who had different disabilities are still here and still with you. And whether or not they have COVID, they still have the right to accommodations, but now it's become complicated because COVID is interplaying with all of those disabilities. So what are the primary statutes that you're talking about? Back to FFCRA. The FFCRA, Family First Coronavirus Response Act, we can all barely remember it now. It was passed back in March at the start of the pandemic. It only applies to companies with 500 or fewer employees. So I fully recognize a lot of you on this call are not under the FFCRA. But for those who are, good thing to remember, it's still in effect. I have had a lot of clients mistakenly think, oh, well, is that over because the lockdowns are over? No, it's in effect through the end of this year. And who knows with a new administration, whether it gets extended. And the bigger issue, of course, would be whether it gets applied to companies with more than 500 employees. It provides for both paid sick leave and paid family medical leave for people who are ill with COVID, people who must quarantine, and people who might need time off, or employees who need time off to allow for childcare, which includes children who are home because schools are closed and there's remote learning. Now, also interplaying is the FMLA. As, as many of you probably know, it applies to a much broader group of employers. All employers with 50 or more employees. It does not, however, cover necessarily the child care piece. It provides leave for the employee's own serious health condition, or if another person in the family, spouse, son, daughter, parent, has a serious health condition. So it also would not necessarily apply to the healthy person who needs to quarantine because of an exposure, whereas the FFCRA might give that person some rights. And then on top of that, I think that's our next one, are the state COVID laws, which Mark is going to cover.
Yeah, so Barbara can tell you, and I can certainly tell you that one of the joys of living in a federal system of government is that you can't just stop by looking at federal law. And so one of the big moving targets for the employers that we work with is you've got an overlay of state law, and then I'll get into it briefly, local law or municipal law in different cities or counties or municipalities, depending on where you are. Now, obviously, it's way beyond the scope of this presentation. It's way beyond any level of patience or tolerance or attention to detail anybody has to go through all of those. So we're just going to throw out a few examples. For example, and this is different from what might apply to a leave situation or an employee's leave entitlement under the FFCRA, which Barbara just described. New York has its own COVID sick leave law. It provides for, depending on the size or type of employer, paid or unpaid sick leave. It expands an employee's eligibility for paid family or short-term disability benefits, specifically under New York state law. So there are these statutory schemes that provide for paid family leave, that provide for short-term disability. It expands the scope of those laws to include COVID-related reasons. Take a look at the second bullet. Employers with 100 or more employees, measured as of January 1st, 2020, have to provide 14 days of paid sick leave during any order or quarantine of isolation. So here's what's significant about that. That entitlement, the 14 days, isn't so different from what you may find under certain circumstances under the federal law. But just note that while the federal law is saying, hey, if you're 500 employees or fewer, the FFCRA applies to you, New York State, and this is not unique to this one state, applies a completely different threshold, and it's not looking downward, but upward. And on this law, there is no firm expiration date. You'll see something similar, but a little bit different, right? And it's the differences that trip up our clients under California law. So Governor Newsom signed Assembly Bill 1867. It was effective September 9th. It's in effect until either the last day of this year or the expiration of any federal extension of the FFCRA. And again, the leave entitlement is not terribly different, at least in terms of how much leave a qualified employer, or qualifying, I should say, employee gets. So up to 80 hours of paid leave. If you're a firefighter, maybe you're entitled to more, and there are prorated calculations for part-time employees. One of the significant differences of the California law is the qualifying reasons. So if you're subject to a quarantine order, you qualify. By the way, that means a quarantine order is specific to the employee, not subject to a general lockdown order that might apply to a whole city or a county or even a state, right? Or you're told by your doctor to stay home and self-quarantine. So those reasons feel about the same as they would under federal law. But the California statute also covers, with this leave entitlement, if the employee's prohibited by the employer from working due to COVID-19 related concerns. What does that mean? So if somebody comes to work, they say, hey, look, I have a scratchy throat, I have a fever. The employer sends the employee home to seek a diagnosis or testing or to quarantine. That's not a doctor, that's not a government saying, hey, you're subject to a quarantine order. The California law covers those circumstances. So again, the point here is more illustrative than comprehensive. These little differences between the statutes are what can trip employers up. Just to keep it fun, all of the municipalities and counties that you see on the screen in front of you right now have their own versions of these things, each with different, sometimes similar, sometimes different thresholds for how big the employer has to be for the law to apply, each with different qualifying reasons, and in some cases, each with different amounts of leave entitlement. So you have that, as I said before, the overlay of federal law and state law and local law. And just to keep going for fun, New Jersey's got its own law. I'm not going to get into a lot of the detail, but essentially it expands. What's significant about New Jersey is there's an existing law that's similar to the Family and Medical Leave Act, just the New Jersey state version of it. The New Jersey law expands the definition of a quote unquote serious health condition. So that's sort of a similar definition under the federal law, but it's now expanded to include unpaid leave for workers who have to stay home to care for a family member. So again, very different from a qualifying reason under the FFCRA. In the case of Pennsylvania, existing law has been amended to extend its paid sick leave law for a lot of reasons. I won't go through them all, but many of them would be familiar to those of you familiar with the FMLA or the FFCRA. But in the case of the Pennsylvania statute, it's expanded to caring for a child. So again, and Connecticut has similar laws and similar regulations. The takeaway again is that you can't just look at federal law or even just state law. If you're operating in different parts of the country, and many of the participants in this program are, you have to look to all three levels to understand, hey, we've got an employee in Sacramento in California, has to stay home because he's not feeling well, or she needs to stay home because there's a vulnerable family member. You can't just look at one layer here. You really have to bore down to the level of the specific locality to understand, do you have an obligation in the first place? Is that a qualifying reason? And if you check those two boxes, then what exactly do you need to provide to that employee?
And Mark, I mean, the state law issue is a big issue for a lot of national employers, because the challenge has been creating, are you going to even try to create a policy that would apply across the board, or are you going to treat people differently depending on the state in which they work, which can sometimes create employee relations issues, can create labor relations issues. So I've had clients go both ways. Some have created national policies, which then are geared to the state that's most generous. Some have created state-by-state policies, which is good for them, but sometimes becomes difficult in the administration. So there's no right answer. The problem is that you have had a hodgepodge of legislation, and you've got to stay on top of all of that.
Right, and kind of further to that point, one of the things that Barbara and I both recommend to all of our clients is this is not a situation in which you want frontline supervisors diagnosing employees and kind of winging this on their own. You've got to have a policy. It needs to be the result of an intentional decision, either to have, an enterprise-wide policy, which sometimes can be over generous in certain jurisdictions, or go on a sort of a state-by-state or even locality-by-locality basis, which, as Barbara points out, can be difficult to administer. What you don't want to do is allow ad hoc policies to develop, because that inherently involves different ways in which individual managers, individual supervisors will implement these rules. And inconsistent policies or inconsistent approaches are, in our experience, what produce legal claims. We also want to turn to, with that as background, some very typical leave issues that we, so these are phone calls Barbara and I have each gotten dozens of times, right? Let's kind of, I'll take the first one. Let's start with the obvious. An employee calls and says, I just tested positive for COVID-19. All right. So just to show you how these laws may produce different results at different levels, under the FFCRA, clearly that's a qualifying reason for paid sick leave. Under the FMLA, is that a serious health condition? Now, the FMLA has not been amended, Barbara, you'll correct me if I'm wrong, specifically to provide that COVID is inherently a serious health condition, but obviously it can result in what the FMLA would consider a serious health condition. And under those conditions, the employee, in addition to the FFCRA leave entitlement, would be entitled to FMLA leave that can be up to 12 weeks, taken all at once or intermittently. Note that that leave is unpaid, unlike at least portions of the FFCRA. Again, we're not going to try to cover the entire United States, but just to give you an example, where I'm sitting right now, where Barbara's sitting in the state of New York, would that qualify for New York paid sick leave? Yes, starting January 1st of next year. And New York COVID sick leave? Yes, but only if subject to a mandatory or precautionary order. So this is kind of an obvious example. You have the employee himself or herself who actually is tested positive for COVID-19. That will certainly be covered under most, if not all, of the COVID laws that we're talking about, but the forms and the amount of leave may be different from state to state. Barbara.
Now, I realize I was remiss earlier, everyone. We encourage questions, and I believe you can electronically ask questions by typing them in on the left-hand side of the screen. Is that right, Mark?
I think it's the bottom of the event tab. There's a Q&A at the bottom of the event tab.
At the bottom of the event tab. And we will get to those questions probably at the end. And the reason we leave them for the end is we find that sometimes the questions are topics we are going to cover. But we will certainly make an effort to answer as many of your questions because we want this to be relevant. And talking about the scenario Mark just put up there, remember, obviously, you're not only thinking about your legal obligations, you're also thinking about your practical employee relations and obligations to this employee in your workforce. The person who's tested positive, just like my person, the person who's been exposed, you don't want them to come to work. Many of you probably have policies that would prohibit them from coming to work. There might be state government orders that prohibit them from going into a workplace once they've tested positive. So while you may not be required to give them time off with pay, there are a lot of layers to these situations that I'm sure all of you have experienced where, okay, maybe I'm not required to give them time off with pay, but maybe I'm going to find a way to supplement some of their pay or give them something for this period they're out, for the simple reason that I want to make sure people honor the quarantine. And that's really this example. So in this example, this employee, Mary, is not ill, but she's been exposed and she therefore has been told probably by a contact tracer, you need to quarantine because you've had direct contact, close contact with someone who was exposed. Is she entitled to the FFCRA? Possibly. If you are subject to the FFCRA. Is she entitled to FMLA leave? No, because in my example, she's not sick. So she doesn't have a serious health condition. Is she entitled to the New York paid sick leave? Yes, starting in January 21. Is she entitled to the New York COVID sick leave? Yes, because she's subject to a mandatory or precautionary order. If she calls you and says, well, how can I stay out, in my example, if you're not going to pay me, I obviously can't give you the advice in real time. But what I've had a number of clients do is to try to find a way to give this employee some amount of paid time because, again, simple reason, you don't want them coming to work, but by the same token, you want to keep the employee and keep them whole. There may be an entitlement to unemployment. Again, that depends on your state. But this is a difficult scenario because you've got someone who can't come to work, but may not be entitled to paid time off, or at least as a matter of law. Which brings us to the next one.
Okay, so what about my daughter was exposed and can't go to school? So spoiler alert, this is not about a school being closed, right? So immediately everybody's mind flips to, oh, school, COVID, somebody's got to stay home. It's got to be those portions of the laws and those portions of the regulations that apply to this situation. No, this is about a close family member is exposed and can't go to school, right? Under the FFCRA, so we're analyzing this as more an exposure issue, right, than a school closure issue. This school is not closed. Under the FFCRA, the answer is, do you have to provide that leave? Maybe. Paid sick leave might be available if the employee is unable to work, is a bona fide need to care for a child who's subject to a quarantine order, right? So the FFCRA does extend that quarantine idea to immediate family. Under the FMLA, again, remember, it's the Family and Medical Leave Act. It's a statute that deals with serious health conditions. That's the trigger that you're looking for. So under the FMLA, yes, an employee would be entitled to up to 12 weeks of unpaid leave, can be sometimes taken intermittently, certainly can be taken all at once, if the daughter is suffering from a serious health condition. New York paid sick leave, possibly, starting on January 1st, that should be 2021. A covered family member's mental or physical illness or injury or diagnosis, care, treatment, or preventive care for a covered family member's mental or physical illness or injury. So it's a lot of words, but the bottom line is, if you have a daughter who's exposed, maybe you're seeking diagnosis, right? We're seeking care for that close family member who has been exposed, probably covered by New York paid sick leave. And under New York COVID sick leave, that relates to the employee herself or himself, and not more broadly than that. So, and I'll just echo what Barbara said in connection with the last hypothetical. this, we're just talking about kind of the legal requirements here. There may be good reasons why, if an employee says, look, I am living with a person who has been exposed to COVID, and you run through the analysis, you call your handy dandy employment lawyer, and that employment lawyer says, yeah, look, in the municipality or the locality where you are, you don't have to provide leave. That obviously is not an epidemiological opinion, right? Or a disease control opinion. And so as a matter of policy, you may well be telling that employee, yeah, you know what, we do want you home. We do want you, if this is possible, teleworking, but don't come to work for, a 14-day, let's say, self-quarantine period.
Now, this next one is, again, become very common as school districts across the country are doing all kinds of things, hybrid, fully remote, coming to school some days a week, free Wednesdays, free Fridays, you name it. Most parents are, literally tearing their hair out. People need to be home to supervise homeschooling. It's a problem because you don't necessarily have the bandwidth to give everyone who needs to be home to supervise homeschooling the opportunity to work from home, depending on your business situation. So what would the law require? As a bare minimum, under the FFCRA, if you're in the under 500 category, there is some amount of time off employees are entitled to, which includes if a school is not open for live learning, that's considered closed for childcare. Does not necessarily apply if the child chose remote learning, which is an interesting scenario. And again, it doesn't also necessarily apply to older children. I think Mark can correct me, I think there's an age cutoff of 14 or 15, where if the child's older than a certain age, you have to demonstrate a need to stay home with that child. So the high schooler, who you may, by the way, need to stay home with more than the little kid, I'm only joking, but some high schoolers need to be supervised, not an automatic time off. FMLA, no. The child's not suffering from a health condition. New York paid sick leave, no. New York COVID sick leave, no. The challenge a lot of clients I found have had with this law is, or this scenario, I should say, excuse me, is there are people who take advantage of it. There are people who are asking for the time off or asking to work remotely because of the children being home from school. And then the employer knows, for instance, that there's a spouse or partner also available at home to supervise the remote learning. And there have also been instances of jealousies developing in the workplace if single or people without children do have to come in. Suddenly the people with children are not having to come in. So you really have a lot of, quote, stuff you need to balance that isn't necessarily legal, but at a bare minimum, you need to comply with your legal requirements so you're not, running into a problem of someone bringing a charge. And getting to the point of bringing a charge, is COVID in and of itself even considered a disability? Of course, the federal agencies, I think that's the next slide, Mark. I can keep talking without it. Don't worry. Anyway, is COVID a disability? Of course, the federal agencies have said maybe. Isn't that brilliant? They have not told us. The EEOC is saying maybe still, if there is an underlying condition. And frankly, for most people who develop COVID or obviously a serious case of COVID with symptoms, they are going to have some kind of condition either arising out of it or will have it before they develop the symptoms. I think what the EEOC is really saying, and maybe meant to say, is there are so many people we know who diagnose positive but have no symptoms. That person is not considered disabled under the EEOC standards. State law, New York City, yeah. I mean, New York City has taken the position that it is a disability. Again, seemingly, even if it applied to someone with no symptoms, and have said that people with the virus are entitled to reasonable accommodations in the workplace. I think that's a bit of an oxymoron. Someone with the virus should not be in the workplace, right, everybody? But you also have to remember to enforce your anti-harassment policies. I haven't heard of it. We thought about it happening in the beginning. I think it's become such a widespread, unfortunately, pandemic that we aren't finding people getting harassed because of COVID, but look, it could happen. And I think this takes us to our next section.
Okay, so we're going to talk about accommodating employees with COVID-related concerns. So when we say accommodation, we're going to get into some elements of disability accommodation, but at least for the moment, we're using the word accommodation more broadly than that. And you know, here's the big picture. It's a virus. It's out there. It's incredibly widespread. We are, you know, in the you know, in the words of the president-elect, I guess, depending on how you look at it, you know, in for a long, dark winter, right? So these issues have been with us since, you know, March. Barbara and I have seen a lot of these issues, and it's only going to increase. And the big picture is this. There's a virus out there. It's a lethal virus. There are people with all sorts of levels of concern. Some of the concerns Mark Konkel, might personally identify with, right? So, you know, sitting on a plane with somebody who's kind of hacking up a lung bothers me. And I think it would bother a lot of people I know. By the same token, I have dealt with employers who are working with employees who say, I am terrified ever to leave my house, which then begs the question, how are you getting food? And things like that, right? Have you actually been out of your house, you know, since March? And so suffice it to say, there's a whole range of risk tolerances, as many levels of risk tolerance as there are people. And we see various iterations of that risk tolerance getting posed in terms of real world scenarios that employers have to deal with. So let's go through a few of those examples. I'll take a few, Barbara will take a few. So in this scenario, all of your employees are returning to work because you're in a business in which you consider, and this may be some point for many of you in the future, not right now, it's safe to go back, or at least as safe as it's going to be, by which I mean the workplace doesn't pose a greater risk inherently than walking out your door under any other circumstances, right? Given that there is still a virus out there and we are at the moment pre-vaccine. So Sue doesn't want to come in because she's a high-risk category, and that can be real or perceived, right? So Sue says, look, I'm older. I hear that older people are more vulnerable. Or I've just finished, you know, God forbid, a round of chemotherapy, and my immune system has been suppressed. I am not comfortable coming to work. So do you have to accommodate that? The big picture here is under the Americans with Disabilities Act and comparable state and local laws, an employer has to engage in a discussion of, okay, what specific accommodation are you asking for? Well, here, Sue is looking for a telework accommodation. And I'll cut right to the chase, particularly under circumstances of the pandemic, where many of you have had workforces teleworking for a long period of time and businesses have not collapsed. It's very likely that teleworking is a reasonable accommodation, because ultimately, to say no, if you're in that position, the employer has to demonstrate that letting Sue continue to telework will pose an undue hardship, which really means a very significant level of operational disruption or a significant increase in costs. If you have to hire somebody else, or if Sue is so instrumental that the business is going to tank when she's not around, physically in an office, okay, that may rise to the level of undue hardship. Now, bear in mind at the same time that teleworking accommodations are not automatic. And we've run into this scenario any number of times where employees say, hey, COVID's out there, and so I want to continue to telework. The answer isn't necessarily yes. Now, my own personal view, professional view, is that to rise to the level of undue hardship, you really do have to be talking about a significant burden on the employer. And it's going to be hard to show that if your business has been up and running for months with a number of employees, or maybe everybody, teleworking. But just somebody asking doesn't sort of relieve them or you from engaging in that interactive dialogue about what accommodation is really required. Now, just bear in mind also, the fact you're getting a telework COVID accommodation doesn't mean that everybody's disabled, right? So, you know, this employee is telling you in the Sue example that she has an underlying condition, right? That's what triggers the ADA accommodation analysis. But the fact that people in general have been working from home doesn't mean that every time somebody says to you, I'm not comfortable going back to work, you have to look at that ADA, Americans with Disabilities Act, back and forth accommodation discussion. Look, as an HR matter, as an employee relations matter, you still have to make sure that people are comfortable. You still have to take reasonable precautions. It's still probably better to encourage or even to require telework when it's possible. Just bear in mind, though, that if and when your business arrives at the conclusion, hey, we are no longer able to do that for some or all of the positions, what you're really looking at is it's not employee preference, because a lot of people just prefer to continue working from home. If you've decided operationally you really do need people back in the workforce, you'll have to engage people in a discussion of that, but it's not a question of disability analysis specifically, unless you're dealing kind of with the SUs of the world.
And this relates to the second scenario. And I will say, look, a lot of our clients are businesses which had to keep operating because you were essential. So you have employees who've been in all along, or now are coming in more frequently, even if they're not, out in the field, they're in the back office type operation. So here you have Sue, who wants to continue to telework, not because she has a problem, but she has a family member in a high-risk category, and she's worried about bringing the virus home. Well, I think the bottom line answer is, again, she doesn't have a legal right to an accommodation, and the EEOC has said that. I think this is the next slide. Because they have a high-risk family member at home, which for many of my clients, both in telecom and in healthcare especially, was good news, because they had a lot of employees in this situation, husband, elderly family member, and they simply couldn't do it. They couldn't let everyone accommodate by letting everyone telework. It also created resentments. The bottom line advice I would give you is just establish a rule, establish a process, and be consistent. So either you're going to accommodate because you can, and certainly you can go beyond what the law requires, or you're simply going to say, no, we cannot accommodate. We're creating a safe workplace for you. And if you feel that it is not safe for you to come into this workplace, then you might have to think about a different workplace. And I've had clients make that decision. And that, I think, gets us to the next scenario.
Okay, so we are still dealing with Sue. Everybody's coming back to work. Sue wants to continue to telework because her child.
Sue is a real pain in the butt, Mr. Konkel.
There you go. But you recognize immediately this is a classic FFCRA issue. It's also covered in state law. It's covered in some local laws, right? Sue is stuck at home because child's school has closed. That is clearly an FFCRA issue, and you're going to get the leave there. Interesting twist to this, frankly, more interesting than the last slide. The EEOC has interesting guidance on caregiving responsibilities, and frankly, the guidance is pretty intuitive, right? Under Title VII, so it's sort of the mother or the father, I guess, of all civil rights statutes, can't treat people differently at work on the basis of sex, right? We all know that. So there are interesting permutations to that. Bear in mind that female employees can't be given more favorable treatment than male employees because of some unspoken or very often sort of unconscious assumption about who the caregiver is. So again, in the framework of accommodation, you have a mother, a female employee who says, I really need more flexibility from you because school, blah, 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 children at home. And you say, yeah, I can understand that. That's a working mother, but you treat the working father differently. This may not happen at a conscious level, but Barbara and I definitely see examples of this happening, kind of these unspoken or even unconscious assumptions in applying policies and applying the way that you're considering accommodating employee requests for a work from home or a telework arrangement, depending on assumptions about who the employer thinks the caregiver traditionally is or ought to be. So just beware that kind of a pitfall.
And also think about alternatives to the full remote work, staggering hours if people are, concerned about a crowded commute, special office, separate workspace if people are concerned about contracting the virus, special PPE, restructuring a job or reassignment to another job where the telework, whether the special shift would be more readily available. Just get creative and be creative. And my last point to you is document. Be sure you document, especially if you offer, and I've had this, offer and they still opt to resign, then they go out and get a lawyer. Make sure you've documented, bullet pointed everything that you have offered this person that they have turned down before resigning the job. Now we have people who are coming back to work. They are returning to the office either in a hybrid model or full-time. So what are we thinking about? We're thinking first about screening, all right? Bottom line on screening is you can screen employees for COVID and for symptoms for COVID. We have developed, and we are using a Kelley Drye app. We developed paper forms for some clients. Are you experiencing symptoms? Are you diagnosed? Were you tested positive? If you are out, why are you absent? Have you been exposed? Have you traveled to a hot state? Those are lawful questions you can ask and require be answered before someone comes to your workplace, whether as a worker or as a visitor. And the next thing is, of course, testing. You can test. You can choose to administer COVID testing to employees. My question would be, why? Okay, unless you are in a business like healthcare where you have access to people who can test, people who can run those tests. If you're a office, if you're a telecom company, to take on the obligation of testing in today's environment, I think would be really difficult. And do it if you need to. If you don't need to, send employees elsewhere to be tested. Virtually everywhere today, testing is readily available. And what do you do when someone says, I don't want to be tested? They have a fever, they're showing symptoms, you're telling them they need to get a test in order to actually work or return to work, and they refuse. I think it's the next slide. Why? Do they have a legitimate excuse? Is there some issue with the testing? I don't know of people having allergies to the testing. Explain the purpose of the testing. And the bottom line answer, people, is if you think this person was exposed, is showing symptoms, and you have a legitimate reason to test them, you can tell them, sorry, no test, no work. It's that simple. But document why. And that brings us to the now increasingly complicated topic of personal travel, as if you didn't have enough to worry about.
So when the fun all started, and I remember it happened even inside the firm, it was a question of if you are coming from Wuhan province or Lombardy in Italy, then you need to do such and such, right? At this point, the virus is everywhere globally.
And then initially, at some point, they added New Rochelle.
Yeah,
that was the first city.
That's right.
I think we've gone beyond New Rochelle. Good news for those in New Rochelle.
Right, just to the east of us, New Rochelle, New York. New Rochelle, as they like to say there now. So let me boil this down to the simplest possible terms. There has been pushback across the country about employees saying, hey, listen, I have a constitutional right to movement. I think a lot of this had to do with a politically charged election season and how COVID itself became a political issue. But let's be clear about what the law says. Can you inquire about employee travel, and does your employee have to tell you? The EEO says yes. And by the way, that's not because somebody's acting ill. You can have a policy that says to employees, we want to know where you've been in general, right? If you've been away, out of state, whatever, we want to know about that travel. And in fact, New York itself and other municipalities and jurisdictions across the country includes travel questions as part of routine screening questions when an employee is coming back to the office. And can you demand, again, in the absence of symptoms, that an employee quarantine upon return? Yes, and it may not even be your choice. The law may require it. When we say, well, what is it, how could the law require it? New York State, for example, its guidance says, and you can see it on the screen, responsible parties, in this case an employer, must immediately notify the state and local health department about the case, we're talking about a positive case, if test results are positive for COVID-19. So bear in mind that you, as an employer, if you become aware that somebody is tested positive for COVID-19, you may have a mandatory reporting obligation. Bear in mind, and for those of you who work in HR, know any kind of medical information should be segregated from personnel files. It's not for general consumption. In fact, when it comes to things like potential exposure from other employees, an employer absolutely can and should interview employees for the employees affected to do some, inter-office, if you will, contact tracing. What about notifying other employees? Does medical confidentiality prevent an employer from letting other employees know? No, not only does it not prevent the employer from letting employees know, arguably you've got under negligence law an obligation to notify other employees and OSHA and general workplace health and safety. Why? Because if you know that Barbara has been exposed to Mark and Mark has now tested positive for COVID-19, we don't know who Barbara lives with. I happen to know who Barbara lives with, but let's pretend we don't know who Barbara lives with. She may have vulnerable family members. She may have a serious health condition or underlying condition herself. So you need to put employees in a position where they know what action, if any, they should take. You don't have to do that by disclosing an individual employee's name, but you could say to Barbara, we are aware that you have come into contact with somebody who is now, in the past 7 days, who's tested positive for COVID-19. please stay home and self-quarantine for 14 days, seek testing, seek treatment or a diagnosis, report any symptoms you have. So just bear in mind, the law at this point has been adapted relatively flexibly to give employers, frankly, quite a lot of power to understand what's happening with their workforce with respect to infection or exposure issues and to respond appropriately.
And look, keep in mind, and I want to make sure we get to our last section, which is things outside of COVID. You don't have to give people paid time off. In fact, many of these laws, like the FFCRA, exempt personal travel. So if I chose to travel to Florida, which was a hot state, and I then have to quarantine, that doesn't require you, the employer, to give me the paid time off under most state laws, and I believe the federal law. So essentially, the employee has to take ownership of their personal travel. And if they choose to travel and have to quarantine, first they have to make sure that they can still do their jobs and work remotely. And if they can't work remotely, then they're taking paid time off on their own dime. They're using their vacation, or they are taking unpaid time off. But personal travel is your own choice. And in today's environment, it's complicated. And the last thing we're going to cover briefly is mandatory vaccine. So the EEOC has said no to a flu vaccine mandate. There are still exemptions for people who have sincerely held religious beliefs and allergies, disability accommodations, barring an undue hardship. In New York, for instance, it's mandated for most healthcare personnel, and many healthcare clients, healthcare institutions require a flu vaccine, and except for people who can really show a serious disability issue. What about the COVID vaccine? We've all heard the frankly great news that they seem to have found one that's very effective and it's in production. Popular opinion, only 35% say they wouldn't, but that's a lot of people. What are we going to do? Actually, interestingly, the New York State Bar Association came out with an advisory today saying they thought the state should mandate the COVID vaccine. Obviously, disability issues to the side, we're going to have the same issues with religion, with disability, and with people who are just spooked by this vaccine. Are you going to require it for people coming into your workplace, people who want to come physically to work? You may have the option to do that. And again, it'll be the employee's personal choice. If they choose not to take the vaccine, they are going to have to abide by the consequences of that choice. You can't force someone to take the shot. What you can say is, look, if you haven't taken the shot, we may not let you come into the workplace and potentially expose others to the virus. And I think that's going to become a much bigger issue as this vaccine rolls out, which is going to clearly be done in stages. So what about everything else? You know, it's not all COVID. We're going to look back, and I want to make sure we also look forward because we have a new administration. So the Trump administration changed a lot. Changed the laws and a lot of executive orders that were developed under Obama. So overtime laws were changed. They actually tightened up who would be considered an independent contractor, meaning made it easier for employers to treat employees as independent contractors. They changed the rules on joint employer. They changed the rules for federal contracts. And they altered the rules for OSHA and exposures to harmful substances. I think that's a typo. The bad news is now that you got used to all those new rules, I think a lot of it may go back. These were major ballot initiatives that were out last week. So Prop 22, a lot of you have probably read about. Basically, the California voters actually voted against the state in a sense that the state had been trying to force mainly Uber and Lyft to classify the drivers as employees by tightening up the definition of an independent contractor. California voters said no. These people can still be considered gig workers and don't have to be treated as employees. Will that go on to other states? I don't know, because I know New York had been doing the same thing. And I think it's an interesting phenomenon, possibly fueled by a lot of gig workers in California, not just Uber and Lyft, who wanted the freedom to be considered an employee. New Jersey legalized marijuana. I know in the cable industry, that's a major issue because as marijuana becomes more of a substance that is legal, you have a bigger problem attempting to regulate it, particularly among the people who drive the trucks and climb the poles. Florida, they amended they raised the minimum wage, and in Colorado, they created statewide family leave. These are just a few things. What do we see happening? And obviously, we are literally looking into our crystal ball and guessing. Mark's going to talk a bit at the end about the NLRB, so I'm going to skip that. I think there's going to be a bigger attack going down the road on class action waivers and arbitration agreements, which have become very popular, but also under attack by the plaintiffs' bar because it's seen as taking away rights. I think arbitrations are very fair. I encourage clients to do it, but I think you're going to see that come under attack. You're going to see the federal DOL regulating the gig economy, and then maybe a fight about which laws are going to apply. Is it going to be the federal law, which is stricter? Is it going to be the state law, which is more employee friendly? Who knows? We know that the current administration tried to roll back and did roll back a lot of LGBTQ regulations and executive orders. I think you're going to see those executive orders rolling back out again. In fact, I think Biden has already announced putting out executive orders on day one. So for those of you who are government contractors, keep your eye on that. And you should make sure your outside counsel is looking at that in December, because if that rolls out in January and you have to get into compliance, you may be dusting off, quote unquote, the policies from pre-2016 and putting them back in.
And the way I would probably sum all of that up is, remember everything that Obama did in terms of workplace regulation, that's everything that Trump undid. And now let's anticipate that Biden is going to re-implement, frankly, a lot of that. So, and still under the umbrella of, here's what hasn't changed. Here's what doesn't.
It's like Back to the Future.
Yeah, right. Harassment still happens in the workplace, and Zoom provides for some really interesting harassment opportunities. I say that obviously tongue firmly in cheek. My favorite example, now this isn't exactly workplace harassment, of Zoom etiquette not being appropriately observed is, I think this was Barbara in the American Lawyer or the National Bar Journal or something like that, but there were two Florida lawyers who appeared in court, meaning, appeared in a Zoom conference before a judge, and it was in video. One guy was not wearing a shirt, the other guy was still in bed. So I'm assuming that this audience is sophisticated enough to, one, don clothing for your Zoom meetings, but if you don't know that, just, make a note. And two, get out of bed before you join. All kidding aside, though, there is, and we saw this kind of like with the onset of widespread use of email, and then more recently IMs, or Slack or things like that. There's a sense of certain forms of communication in certain work environments being more informal. Well, in a world where, many of us are still teleworking, the workplace is, I happen to be sitting in a home office right now. This is my workplace at the moment. And so, remember that there could be remote complications to harassment claims. There's also, as Barbara pointed out before, we see an increasing number of pandemic-related harassment claims. Somebody says, hey, listen, I've got a medical condition. It happens to be related to COVID. I'm getting a hard time at work. People are ostracizing me. So harassment definitely still happens. And recall, if you didn't know this already, that the EEOC, the U.S. Equal Employment Opportunity Commission, has its own enforcement capabilities and its own enforcement mandate. So it brings lawsuits against employers directly. It's not just employees pursuing claims against their employers. I'm not going to sit here and read you these cases. You're going to get the slides after the fact. But note kind of the secondary bullets in each of those. What really got the employer into hot water and gave these employees claims was a lack of anti-harassment training and a failure to investigate claims, right? So even if there wasn't underlying harassment, what can complicate an employer's situation legally is where you're not trying to prevent it in the first place through training, and when you don't have a robust investigation and an HR process around that to try to respond appropriately when unfortunate situations do crop up at work. So just consider that.
And Mark, before we get off harassment, the one thing I've seen, and you should all be aware of, is employees harassing others, managers, whoever, through text messages, often on private cell phones, because we're all using our cell phones now for work. Are you liable for that? The answer is yes. Okay. If this is a work-related or maybe even not a work-related conversation, but they're in touch with each other because they work for you, and the female employee complains that the guy is harassing her even over his personal phone, investigate it. You could be liable. Once you're on notice, do something about it.
And that has always been the case, but you know, we see a more pronounced risk.
Well, the workplace has bled out of the workplace. And so, you know, I'm taking business calls on my personal phone. I'm texting my colleagues on my personal phone. I can harass people on my personal phone. So just be aware of it because you're liable.
And we're going to move through some of this last bit of content to save time for questions pretty quickly. Pregnancy discrimination, just recognize that can be a form, obviously, of discrimination or harassment. If you take away nothing else from this slide, I'll leave you with this one thought. I think the worst thing that you can say to an employee on the way out the door in a termination situation is, we just don't feel like it's a good fit. Now, obviously, that's usually intended as a euphemism, right? Because we'd rather not say you're no good at your job or you know, some other concrete and kind of harsher criticism. The problem with good fit is it can mean almost anything. And employees are very happy to find attorneys who can say, oh, well, the employer wasn't very specific and didn't fill in that blank as to what that means. I'm happy to fill in that blank. It was pregnancy discrimination. It was COVID-related discrimination. So be specific in the way that you're describing performance issues and communicating employment decisions to employees.
And just quickly on this, a lot of you might have read about, if you're in this, follow this, that the EEOC came out with a statement that employers must accommodate those who are prescribed opioids for pain, which caused a lot of my clients to get into a complete, you know, hissy fit. Good news, common sense prevails. You can still fire someone who's high on opioids if they come to work under the influence and cannot perform their job. That's number one. Number two, if it's not a legal prescription, so if it's someone who is illegally using a substance like heroin, you can still terminate them. So a lot of this is common sense. The same thing about marijuana. Okay, marijuana is legal in lots of states. So's beer, everybody. We can still fire you if you come to work drinking beer. Remember that, Mr. Konkel, the next time I see you with an open can. Kidding, but seriously, treat marijuana the same way you treat alcohol. People cannot be at work under the influence, period, full stop. The trickier thing is sometimes it's harder to tell if they're under the influence, but that's still the rule of course. And that's what this case stands for. You'll be getting these slides. If there is a positive drug test, it's lawful and it's a non-discriminatory reason, thank God, for terminating a nurse, okay? Common sense prevails. I think that is the lesson. Layoffs, quickly, we have to consider the COVID pandemic is not an excuse to get rid of the dead weight, the older people, the people who've been underperforming, but that was never documented. You still need that documentation, especially in this case, if you're going to fire someone who turns out to be the oldest person in their department. Issues to look for, I think LGBTQ issues are going to continue to be an issue in front of the Supreme Court. We are going to be looking at gender identity as an expanding area, especially now that we have a Democratic administration. And Mark, take us home with what you see happening at the NLRB.
Everyone's favorite subject.
Or unless you have questions. I mean,
yeah, so look, one quick kind of fun fact, don't forget to watch the NLRB. It regulates
fun fact
as well as unionized employers. There was a fantastic case, I think from 2016 or 17, where an employee was fired for calling his boss a nasty mother F fill in the blank. We have now clarified that you're not allowed to do that at work. So thank you all. I know that we can switch to questions at this point, so let me pull up some of those. Okay, great.
So we have some people out there.
We do. We've got some people out there. So
okay.
If an employee states that they are experiencing COVID-19 symptoms, but they haven't been tested, no exposure indicated, how should they be handled in New York City? Barbara, you want to take it?
I think they should be told that they should be tested and should not come back to work until they are shown to be negative.
Yeah.
Simple.
Here's a sort of
safety first. You got to be safety first.
That's right. Here's a similar question. What's our position on asking somebody for a copy of test results? I'll take that. You have a right to confirm that somebody's actually had a test result, and you don't have to rely on an employee to self-report. Now, obviously, you have to treat those are medical records. You have to treat them and with great sensitivity and confidentiality, but it would be like any other medical accommodation issue. Your doctor says you need X. I'd like to see the documentation. You handle it confidentially, but you're entitled to confirm that. Okay. How about this one, Barbara? If a child is exposed and required to quarantine, but they don't exhibit symptoms, would they be eligible for FMLA leave? I think we both know the answer.
Right, not a serious health condition.
Right. Okay. How much time do we have left? About
40 seconds.
Let's jam in one more.
Pick a good one.
Yeah. Okay. So we have an employee who wants to travel for Thanksgiving, but we need them in the office the week after. Do we have to say yes to the travel, knowing that the impact of that is that they have to quarantine for something like 10 to 14 days? Barbara, you want to take that one?
No, I mean, no, you don't have to. But A, think about the employee relations issues. B, however, think about what you need them for and when you actually need them in the office. But if you legitimately need them in the office, the travel for Thanksgiving is a personal choice, and Thanksgiving is not a religious holiday. I might be answering you differently if you said it was Easter or Christmas, because
And
it's
with that,
motivation.
sorry to cut you off, Barbara, but we are now at 0. Thank you all for tuning in. We appreciate your time, and you'll all get a copy of the slides. Feel free to follow up with us if you have any other questions, because there will be a lot of them coming up. Thank you.
Thanks a lot.